the first to know Nsem-Pii TV.
Nsem-Pii TV so. Member of Parliament for a Asino constituency, Onimram for Gyakye Quayson. Enyim say ne court ruling no edaso ho. Na Gyakye Quayson the Attorney General and the Minister of Justice Yera Godfred Odame akopimo the Disciplinary Committee of the Ghana Legal Council. Say Godfred Odame obrana previous ye no Gyakye Quayson abai omko na ase no asetina no. Godfred Odame actions be or no court no violate the rules of professional conduct. Na nsem we na Gyakye Quayson dey akoda the Disciplinary Committee so mo hwehwem. Eno na obi awden dwuma ya Nsem-Pii FM abebreki asem we down. No we osa kasafa Mami Sister Dapa former Minister for Sanitation and Water Resources. Ono sende court call na asem so asetina ne nsem bofru on so bane de. Na Nsem-Pii message be ko na kotie Gyakye Quayson de na o kafa Godfred Odame de no. Mi wi anam sade Mami Sister Dapa de na to aso no mo TV. Na Nsem-Pii message be ko. Nyakwaje nsem we mienu emunchirimom ankasa ifri obi ho eba.
1st of August
of this month.
Yes, exactly.
Okay. While at that, no, still on legal issues, no. Office of Parliament, Honorable James Gyakye Quayson, Member of Parliament for Assin North, were thrown to the Chairman, Disciplinary Committee of the General Legal Council, Accra. Your Lordship, report of professional misconduct by the Honorable Attorney General Godfred. Godfrey, that's why ni chat to Godfred Odame. Or say, I respectfully seek to initiate disciplinary proceedings against the Honorable Attorney General, again, repeated Godfrey Odame, for his professional misconduct during and in respect of my criminal trial in the High Court Criminal Division 3, Accra. At the last adjourned date, 19th July 2023, during the cross-examination of the first prosecution witness, Richard Techimensa, after the witness had testified confirming that he had given a statement to the police to which he attached certain document, which testimony is also reflected in the police statement itself. The Attorney General, responding to an application by my counsel for disclosure of the attachment the witness referred to, stated that there were no attachment to the said police statement. This clearly amounted to providing testimony to the court, which I am advised and believe to be true, is clearly contrary to the rules of professional conduct by lawyers in a case. The quote testimony unquote provided by the Attorney General contradicted the testimony of his own witness and was presented for the first time without any prior notice to my lawyers or myself as to the fact known to the prosecution. Significantly, after the intervention of the Attorney General, when my counsel asked the witness whether he still stood by his testimony that he had attached documents to his plea statement, the witness would not provide an answer to the question. In effect, the testimony of the witness had been influenced by the professionally improper testimony of the Attorney General. My counsel has applied for a certified true copy of the proceedings before the trial court on that day, and I would make this available to the disciplinary committee as soon as it becomes available. There are also the following further instances of professional misconduct on the part of the Attorney General. On 16th June 2023, when my lawyer was seeking to bring to the attention of the court that I was a candidate in the then pending parliamentary by-election in the Assin North constituency, the Attorney General used the following insulting language against me. Quote, "This is what I describe as a very totally irresponsible step. Beside it, to apply to contest again when he knew that these proceedings were pending for which he can go to jail." Unquote. This gratuitous insult on the part of the Attorney General was without any basis and had no place in the trial, and I'm advised by my lawyers is contrary to the rules of professional conduct of lawyers. I attach herewith the record of proceedings before the court on 16th June 2023, during which the Attorney General made the insulting remarks I am complaining of. The Attorney General has also misconducted himself by his granting of at least one media interview in relation to my case. the Attorney General has claimed in court that his comment followed a decision of the Supreme Court in respect of an application for an interlocutory injunction restraining me from performing my duties as Member of Parliament and were not in respect of my criminal trial. It is my understanding that the rules of professional conduct do not allow lawyers to grant media interviews in respect of cases they are handling. Thus, whether the media interview of the AG was in respect of the civil case in the Supreme Court or in respect of the criminal trial, the grant of such an interview was contrary to the rules of professional conduct for lawyers. In reality, the said media interview, in its terms and at a time when the AG had initiated criminal proceedings against me, was clearly understood by the public as being in respect of the outcome of the criminal trial also, and was clearly prejudicial to me. I attach herewith a report in the media of the prejudicial remarks of the AG. Through his professional misconduct, the AG has clearly jeopardized my fundamental human right to be presumed innocent until I am proved guilty, and my trial and my right to a fair trial. I therefore respectfully request disciplinary proceedings against the Attorney General for professional misconduct as outlined above. Yours sincerely, James Gyakye Quayson, MP, Asin North constituency. This whole Gyakye Quayson sends something from Central Region and the demand BPA Court of Appeal, a court Supreme Court. As we speak, Supreme Court, the civil now has been dealt with. Criminal partner Koso. And I think in the criminal trial, no, one my instance that just say, or see AG can be
and it actually came up in court. So we share this letter to the GLC now, two.
Yeah.
In two folds. One, alleged prejudicial comments by the AG, and the second one, the fact that AG was handling the matter and was granting media interviews, and which he feels that it's against the media,
the professional conduct of lawyers.
Yeah. So when the matter came up, there were two. The president voice at Asan North during the rally was played. I think a bit of it under 2 minutes was played. And then there was an objection by the AG indicating that if they will play the voice, then they should situate it within a proper context. And so the entire 13 or 15 minutes of it should be played in court. In fact, that matter ended. And then it wasn't only the AG that was cited for some prejudicial comment, but the president as well. So now what I see him doing is to go a step further. In fact, the judge ruled that it did not in any way affect the current case that was ongoing at that particular time.
For president, the voice, no?
Any
AG.
Exactly. So it was raised. I mean, it was raised.
The trial judge no ruling.
Exactly. So it was tendered in evidence, actually. So that's what I was telling you, that the voice of the president
was tendered in evidence.
Yes.
And it was played.
It was played.
And the judge gave a ruling on that.
Yeah, so the judge
to the case.
Exactly. And so that one, I mean, came to nothing at that point in time. So so when I see say they are taking it to
a step further
to professionally situated. Exactly. Say in number 2, and we've heard it says, oh, your case, you don't have to grant interviews. It's a case, it's related to you, and as a 100 case now, you don't have to grant it.
But was that issue also raised in court by lawyers?
No, so I'm hearing
the
this
bit about the interview.
Yes, the bit about the interview is now news. But this the prejudicial comments I think it's come out before. Yes.
Okay, let's see. GLC, interestingly, the AG himself is part of the GLC, General Legal Counsel. And I think AG also in appointment, the AG was some reps are no appointee onto the GLC apart from himself. President were reps, some of the law faculties no reps. So the Chief Justice himself is the chair of GLC. Let's see how that would pan out. A very interesting.
But Gyakye case in there very, very interesting. So now there is a bit of reprieve. Following the adjournment of the case to October when they are back from the legal vacation. And so because it's still a long winding road.
Very, very long. In Tiene, Cecilia Semno Echo, a him for court bear.
Financial and Economic Crimes Court.
Yes.
So
Okay.
A division of the High Court.
Yeah. It did not almost a day important in a court.
One thing that you're crying record anymore. It was a virtual court session.
Oh, okay.
So
yes,
the OSP
legal break, legal vacation.
Exactly.
Okay.
The OSP did not come to court, but they were represented by Dr. Isidore.
Okay.
And then Madam Cecilia Dapa was also represented by Victoria Bath.
Victoria Bath.
Yes,
okay.
exactly. So so the judge was in court, all right, but the two parties were not exactly. So we the journalists were given Google Meet, and then we had to join outside the court.
Oh, okay.
It was an interesting session actually. So Madam Cecilia Dapa, as we know, she was not in court, but there was an application by the Office of the Special Prosecutor to confirm the freezing of the monies found in Cecilia Dapa's house. That is one. So there were two, in fact, two strands of the argument. The first one was the freezing of the account in her house, and the second one, the freezing is in respect of the account, and then the seizure is in respect of the Nifio. So there were diverse arguments, but so the argument made by Cecilia Dapa representative was that the OSP was perpetrating illegality because they should have come within the mandatory 7-day period within which they could apply to the court to confirm the seizure and the freezing. So on 1 year they feel that some illegality is being perpetrated and that the court should throw out the application being filed. So the fact that monies were found in the matrimonial home of Cecilia Dapa doesn't mean that there is some wrongdoing or some corruption or corruption related
offense.
Will be exactly the same thing that the fact that there are money standing to the credit of Cecilia Dapa in the account doesn't mean anything. Say be a wire bonny and untin a sikano guna account him and the client in idea. I mean things are legitimately done, and the OSP is swimming along the media frenzy that is currently ongoing, and that was really what happened. Until they pray the courts, say court OSP asem no de buy
OSP in so argument on 7 days mandatory period near then.
Well, I'm saying they are within the law. They have come. So there were argument of shall in the OSP Act and all of that. But I mean, we will leave it to the court. The ruling on the 31st of August, whether the court will uphold the argument by the OSP or will side with Madam Cecilia Dapa representative.
It is part of our application, OSP, in the application, name the amount involved.
Well, so on the first one, they named the amount found in her home. That is $590,000.
$590,000.
Yes,
and only official in the court document.
In the court document of monies found
in her home.
Exactly.
$590,000
when they conducted their search. And in addition, they also found 2.7 million Ghana cedis. In the
$590,000
plus
and a
2.7 million Ghana cedis.
So we need the OSP, they are court.
Exactly.
So
exactly. And on that basis, in into and the courts by the OSP Act should confirm. Say this is what they have done, and should give legitimacy to
our action
to that one.
Okay.
And then
second,
bank account, all that the two parties indicated in court. They didn't mention the names of banks in question. The banks they made the enquiries. They didn't mention them. They did not also name any amount
in any of the accounts.
But now where the argument was going. I was tempted to believe say amount to be say these were the amounts standing to the credits of Madam Cecilia Dapa, but nothing of that sort was done. And then basically that was what happened in court. The judge inquired why the money were found in the matrimonial home of Madam Cecilia Dapa. It was only Madam Cecilia Dapa who was arrested. Then the OSP said that both of them were placed under arrest. So they put it on record that both of them were arrested. So it wasn't only Cecilia Dapa. The fact that the money was found in the matrimonial home of the couple, both of them were arrested. And so the questioning would be for both of them.
It is here, you're granted one bail.
Yes,
right?
they've been granted bail. So this case is substantially and materially different from the case that is currently running
the
in the criminal.
prosecuting.
Exactly.
Okay.
And for that one, we will be in court on the 22nd. But the ruling of this application will be on the 31st.